Balgobin Maharaj against the Cabinet of the Republic of Trinidad and Tobago and London.
Lord Richards will explain the Board's judgment.
On the 2nd of December 2019, local government elections were held in Trinidad and Tobago. Councillors and aldermen were elected for a period of 3 years in accordance with the relevant legislation contained in the Municipal Corporations Act 1990. These councillors and aldermen were accordingly due to vacate office at the start of December 2022, with local elections to follow by March this year. Further legislation was passed by Parliament and received assent on the 1st of July 2022 to amend the 1990 Act. The new legislation amended the 1990 Act to alter the structure of local government in various significant respects, including by increasing the terms of office of councillors and aldermen from 3 years to 4 years. It did not immediately come into force. Power was given to the President, on the advice of the Government, to issue proclamations to fix the dates on which all or any parts of the new legislation were to come into force. On the 7th of November 2022, the President issued a proclamation which brought into force just those provisions which increased the terms of office of councillors and aldermen. The Government announced that the effect was to increase not only the terms of office of councillors and aldermen elected in the future, but also those who had been elected in 2019 for 3 years and would have vacated office in December 2022. The issue on this appeal is whether the effect of the amendment was, as the Government maintains, to increase the terms of office on the incumbent councillors and aldermen. On an application for judicial review, the Court of Appeal held that the Government's interpretation of the legislation was correct. By a majority, the Board holds that the amendments did not have the effect of extending the terms of office of the incumbent councillors and aldermen, and that therefore local government elections should have been held by March this year. The majority judgment is given by Lord Richards, with whom Lord Reid and Lord Hodge agree, and the minority judgment is given by Lord Briggs, with whom Lord Kitchen agrees. The Board considers that, even read on their own, the amendments apply only to councillors and aldermen elected in the future, but it accepts that there is a degree of ambiguity in the language used. However, in the light of the context and purpose of the amendments and the applicable principles of statutory construction, the Board is satisfied that the amendments did not apply to the incumbent councillors and aldermen. The election of representatives for a fixed or maximum period is the foundation on which a democratic society is built. It is inimical to a representative democracy that the representatives are chosen by anyone other than the electorate. However, if the relevant amendments were to apply to incumbent representatives, the effect would be that the Government, rather than the electorate, had chosen those representatives for another year. General or ambiguous words are not a sufficient basis for interfering with the basis on which incumbent representatives have been elected. The amended provisions do not contain the clear language required to extend the terms of the incumbent councillors and aldermen. For these reasons, which are more fully set out in the judgment handed down today, the Board allows the appeal.
The hearing is now adjourned.